By. All participants are on a listen-only mode for the duration of today's call. I would now like to turn the call over to your host, Mr. Patrick Shepard.
Great.
Thank you, Mr. Shepard.
Thank you, Michelle. Good afternoon and welcome to the latest exercise in our 278 Reviewers Massive Open Online course. We're very fortunate today to be joined by Mark Stewart from OGE's Compliance Division. Mark has many years of experience reviewing public financial disclosure reports, and today he's going to take us through an exercise to help us see some common issues that we find in the review of 278Es. For those of you who are new to the practice of reviewing 278s, you may find it helpful to watch part 1 of the Massive Open Online course. In that presentation, we cover a number of the rules that you'll need to be familiar with in order to review a 278, as well as some common reporting issues, as well as the purpose and history of the Public Financial Disclosure Review Program. So this presentation will be helpful to you if you've never done this before, but it may be even more helpful if you refer back to it after watching part 1. So I think we have a lot to get into today, Mark. Shall I go ahead and pull up our exercise?
Yes, please do, Patrick.
Excellent. And while I'm doing that, those of you who are joining us virtually, it may be helpful to you to have out a copy of the exercise 278E so you can follow along and take notes as Mark walks us through the exercise. So Mark, it's all yours.
Thank you very much, Patrick. Hello, and once again, my name is Mark Stewart, and I'll be presenting this session. What I'd like to emphasize is that this really isn't an exercise. It's going to be just a lecture for about an hour. Let me introduce myself. I work in the Compliance Division here at OGE. I've been at OGE for about 14 years, and before that, I was an attorney for the United States Coast Guard. Now, as part of my Coast Guard duties, I was an agency ethics official as a collateral duty, which is fairly typical. And I also worked on financial disclosure as part of that collateral duty. So I like to think that I've seen this on both sides, both from the agency and from OGE's point of view. This course is designed to be a refresher for people who have already done basic financial disclosure, or at least have done it before, but who do it as a collateral duty or a part-time assignment. My personal spin on this is that the first time I was assigned to do financial disclosure, I said, great, what is it? I had no idea what financial disclosure was. But I educated myself, I came up to speed, and I reviewed all my reports. The next year, when I was assigned to do it again, I said, great, what's that? Oh, right. I pretty much had to start all over again because I had forgotten everything about it. That's pretty typical, at least for me. What we are going to do is walk through a draft 278E and presumably remind ourselves about potential issues for financial disclosure based on the entries on that form. Once again, this is just a refresher. I'm assuming that you already have the basic knowledge of reporting requirements, conflict of interest issues and statutes, OGE regulations, and remedies. Right at the beginning, one thing I'd like to highlight is that OGE is actually a pretty good resource. If you do have questions during your reviews, I recommend that you start with the instructions to the 278E form. In fact, I recommend that you go through the instructions to refresh yourself at the beginning of each annual reporting period. In addition, if you have the time, I recommend that you go through OGE's regulations on financial disclosure at 5 CFR Part 2634 and Part 2640. I used to do live training here at OGE, and every time I said that line and then looked up, everybody was rolling their eyes. However, as regulations go, they are really not that bad. They give the basic requirements, but also have notes and examples which can help you both when you're doing your review and when you're dealing with your filers. I also recommend that you remain familiar with OGE's website, when you can find both the form and the regulations and other OGE guidance, both on financial disclosure and on particular ethics issues. I especially recommend the guides and the OGE advisories. Finally, based on your agency hierarchy, first off, there's a good ethics support system amongst the agencies, which is great. And every agency has an OGE desk officer. Now, your agency's designated agency ethics official is responsible for your agency ethics program, but the OGE desk officer can always give advice and guidance, once again, depending on how your agency is set up. If you are listening to this training session and you are new to ethics and financial disclosure, that's okay. Hopefully you'll get some pointers from this. But I really recommend, as Patrick said, that you go to OGE's training website and review all of the basic material there. Ethics issues can be extremely complex and are very fact-specific. Plus, the concept of a conflict of interest is based on a criminal code at 18 U.S.C. 208. People can and have gone to jail because of this. Just as a reminder, just so we all know, a conflict of interest is where a federal government employee takes an official action that impacts on their financial interests or their imputed financial interests. One of the main reasons we do financial disclosure review is to help our employees avoid this. What we do as ethics officials is review their financial disclosure reports, compare their holdings to their official duties, and determine if there is any potential overlap. For example, if our employee is a contracting officer who is going to be awarding the contract for new computers for our agency, and Dell Computers is a bidder, and we can tell from the employee's financial disclosure report that the employee has stock in Dell Computers, we need to intervene before our filer takes any official action on that bid. Because awarding the contract to Dell could presumably increase the value of Dell stock, which would increase the value of the filer's holdings, which would be the impact. In short, this is why we do this. In that scenario, our filer has a potential conflict of interest. But as long as the filer hasn't taken any official action, we just have a potential conflict of interest, which can be remedied. For example, the filer could divest the Dell holding, or we could have somebody else work on that particular bid, etc. As long as we know in advance, we can remedy the situation. However, if our filer has taken an official action, then we're dealing with a crime. The situation has to be investigated by our IG and subsequently referred to the Department of Justice. My quick side story on this is the Marvin Runyon story. He was a political appointee back in the Reagan era. He was an all-American hero. He was born poor, brought himself up by his bootstraps, became a successful businessman, and was brought in by the Reagan administration for his business acumen. At some point, he ended up as the Postmaster General, and he had a great idea about combining business with the federal government and thought it would be a great idea to have a soda machine in every post office. That's great, but he was specific and wanted the machines to be Coca-Cola. Now, he took official action. He had meetings, he drafted memos, et cetera, and that was fine. But when word leaked out, the value of Coke stock rose. Now, what did Marvin Runyon own amongst his other holdings? Coca-Cola stock. So when that went up, that was the impact that he had. You don't want to be the ethics official who has to walk down to the front office and say, boss, we may have a problem. But there was an issue, there was a conflict of interest. It had to be investigated by the IG, and it had to be referred to the Department of Justice, and the Department of Justice prosecuted. Did he ever go to trial? No, it was settled, but it was a big embarrassment all the way around. On that note, let's talk about OGE officials. I'm sorry, agency ethics officials. They can and have been called in to testify in criminal trials as to what they did or did not advise federal government employees when it came to ethics issues. What I'm saying here is that it's always a good idea to keep good notes and records. Okay, on that note, let's walk through our report for our imaginary filer. Since this is a refresher, I'm presuming that everyone is familiar with the 278E form. Back in 2015, this became mandatory. So this is our second season with this form. And as you know, we are required to keep these records for 6 years. So you may have prior reports that are in the old 278 format. The information reported on the forms is the same, but the layout is a little bit different. I'm not going to talk about integrity, but if you have that at your agency, then you know that's what you use for both your filers and your review of the 278E form. Okay, let's take a look at the cover page. For our purposes, it's an annual report for the lead procurement person at our agency. And once again, this is just for training purposes only. The annual year, you see it says 2000XX. That was just me, so I don't have to change this if I have to do this reporting presentation again next year. We can see that the filer has been here since 2014, so you should have a new entrant report and at least one prior annual report for that filer. I strongly recommend that as part of your review process, you compare the current report to the prior reports. If the holdings are the same and the filer's duties have not changed, then that should make your review process much easier. For our purposes here at this lecture, we're ignoring the fact that the report has not been signed and dated by the filer. Okay, it's a bit of a rehash. As you know, our review is a two-step process. First, this is a congressionally mandated duty, and we have to make sure that the filer has filled out the report fully and completely. Then we see whether any information on the report would lead us to suspect a potential conflict of interest. Remember, these reports are just a starting step. As Patrick used to like to tell me, we should regard these as a request for advice from the filer. What we do is we do our potential review, and if we see an issue, then we go forward with that. We may have to obtain additional information, even though that is not required to be reported. We just need to resolve any issues, whether we see them on the report, quite frankly, or not. We cannot certify a report until we are certain that our filer has no conflicts. And once again, you have 60 days to review the report, but it is publicly releasable after 30 days. And once again, it has to be maintained for 6 years. Also, remember, you have no attorney-client relationship with the filer. This can be awkward, since you may have to ask the filer questions about personal holdings and relationships. Okay, let's take a look at part 1. This is where the filer reports any positions held outside of federal government service. Our first entry indicates a position in a homeowners association. The filer has filled out all of the required information and has held the position since 1989. Presumably, this position has been reported on the prior reports and was vetted when the filer was first hired. So, technically, the filer has filled out the position correctly. Next, it does not appear that the position would present a potential conflict of interest with our filer's duties. However, if the filer is reporting this for the first time, or if we suspect that there could be a new potential conflict of interest, we would have to obtain further information from our filer. Now, let's take a look at the second entry. First off, it is not filled out technically sufficiently since we don't have a city or state for the organization. But wow, our filer works in procurement at our agency. In fact, our filer leads procurement in our agency, and he's consulting with an outside entity. This should get your attention. First off, most agencies have requirements for prior approval for outside activities. Usually that is handled by the legal branch, which also usually handles financial disclosure. If we are seeing this for the first time, it's a big concern. First off, we need to make sure that our filer doesn't take any official action that could lead to a conflict of interest. Second off, we will probably need to get with the filer and everybody else involved in the chain of command to remedy this, probably by resigning from his outside position. Conversely, if this outside position is a part of the filer's official duties, then it was not reportable in the first place and is not an ethics concern. The big thing to remember about this is that if one of our filers has an outside position, they are prohibited criminally from reporting back to the federal government on behalf of that outside entity. My story is that I had a Coast Guard junior officer who wanted to set up an entity to essentially refloat a floating Coast Guard cutter that was a museum. That's fine, that was good. We got him the outside position. But the first thing he said was, when he walked out of my office, was, now great, I can go sign this letter requesting funding from this federal government agency. And I'm like, whoa, my bad, come back, you can't do that. Bottom line is, if our filer has outside positions, hopefully we know about it in advance and everything has been vetted.
I think this is maybe a good point to remind folks that we do also have an outside activities massive open online course. So if you're not familiar with that process, there is some help available. And we're actually planning to add an exercise to that in the coming months.
Excellent. And once again, when I was by myself at my agency, the OGE website was a great asset. Okay, now let's go to part 2. And this is where the filer reports his or her employment assets and income and retirement accounts. Entry number 1 is an IBM defined benefit plan. If you're not familiar with the concept of a defined benefit plan as opposed to a defined contribution plan, once again, OGE has a lot of guidance. The filer reports it as pension income, which is fine. It's fairly common for employees to have pension interests with prior employers. The assumption here is that this was vetted when the employee first came on federal government service, and the employee would be advised not to take any official action that could have an impact on IBM's ability or willingness to comply with the future payments of the pension. If our filer can take an official action that puts IBM out of business, wow, then we need to talk. Technically, the filer left the value blank. Typically, what we see in situations like this is we really don't know the value of a defined benefit plan. So the filer would enter a phrase such as not readily ascertainable or something along those lines. Once again, if we are seeing this for the first time, it would appear that the employee inadvertently neglected to include this. So we will have to consult with our filer. Item 2, the filer is reporting consultant fees based on his outside position. First, we still have our problem with this, and it's great that our filer is telling us this, but we will probably still need to take remedial action to resolve this issue as discussed. If the filer is being paid, then it's safe to assume that this is not part of an official duty. Hey, the filer just may not know, or the filer may have inadvertently omitted it. So this is one of the reasons we hope that our agency ethics officials have a good one-on-one relationship with the filers. Okay, let's go on to part 3. This is the filer's employment agreements and arrangements. It may seem redundant since the filer has reported his pension previously on this report, but he still has an ongoing relationship with the prior employer, in this case, IBM. So the entry still needs to be made here. A takeaway from this is that it is not uncommon for a filer to forget about prior arrangements. For example, 401ks, pensions, severance payments, etc., with prior employers. If we see this, we should note our basic conflict of interest screening questions, and it's always a good idea to counsel the filer and note this to the file and maybe even on the form. Here at OGE, we see inadvertent omission a lot. A lot of people just forget their prior connections with prior employers. Part 4. This does not apply to annual filers. If you're dealing with new entrants and nominees, then I presume that you're already familiar with this. Okay, now let's take a look at part 5. This concerns the spouse. Item 1, the entry about spousal salary appears to be technically correct. We don't need an exact amount of salary for a spouse. And once again, hopefully we can just compare this to the filer's prior annual report. However, if this is a new entry, we will have to consult with the filer to ensure that this is not a potential conflict of interest for the filer's duties. And we would also ask the filer follow-up questions to ensure that we have all the information on the spouse's salary and benefits. For example, is the spouse just a salaried employee? In that case, that's fine. However, if the spouse is a senior executive with a more complex compensation package, it might have other reportable components which we would need to talk out because those could be imputed to the filer. Entry 2, this is a bit of a problem. The 401k itself is not an EIF. It is just a holding entity. We need to go back to the filer to find out the underlying holdings of the 401k, since the spousal assets are directly imputed to the filer. Also, the assumption is that the 401k is with Clark, but we need to verify that and update the report on that as well. Okay, let's go on to part 6. This is where the filer reports other assets and income that are not directly related to his or her employment or his or her spouse. Item 1, IBM stock. We have a value, an income type, and an income amount. It appears to be a security and appears to be technically correctly reported. Once again, if it was on the prior report and the filer has no new duties that interact with IBM, then we should not have a potential conflict of interest. However, if it's new, we may need to do some digging. Item 2, this appears to be a mutual fund, Fidelity Puritan Fund. It is marked as yes as an EIF. We have a value. We don't have an income type, but we don't need one for an EIF. And then we have an income amount of none or less than $201. I presume that we're all familiar with the concept of a mutual fund. A mutual fund qualifies as an EIF, which is an accepted investment fund for reporting purposes. This means that the filer doesn't have to break out the underlying assets. Our major concern here initially is whether this is a diversified mutual fund or a sector mutual fund. OGE has determined that diversified mutual funds are not a potential conflict of interest. However, a sector mutual fund could be, depending on the circumstances. If we are unsure, we need to do some digging, find out what the fund is, and then also take a look at 5 CFR Part 2640, where OGE has guidance on sector mutual funds amongst other holdings. The next issue I'd like to bring up here is the ticker symbol that follows the fund name in this entry. It can make it easier for reviewers to do their research. The one thing to remember here is that while the ticker symbol is a great addition, filers are not allowed to enter just the ticker symbol itself. OGE has determined that this is not sufficient for reporting purposes, so we need the full asset name, and the ticker symbol is just optional. Item 3, it's nationwide managed account. EIF is checked yes. We have a value, an income type, and an income amount. The takeaway from this is that if you ever see the phrase managed account, it should get your attention. First off, the managed account itself would not qualify as an EIF. The managed account is an agreement with a broker where the broker can buy and sell assets for the filer, but those assets are still owned by the filer. So the filer would have to report out the underlying assets of the managed account. In addition, this type of holding entity has a higher potential for a conflict of interest since the broker is buying and selling on the filer's behalf, but the filer may not find out the specifics until later. You may want to consider having the filer give restrictions to the broker, or maybe, and we do this for PAS types, just close up the account. It's just too high of a risk for a conflict of interest. So the bottom line on that one is managed account is not an EIF, and we would need the underlying assets. Item 4, 529 plan. We have a value. We don't have an income type, and the income amount is none. That's fine. 529 plans are a means where the parents can set aside money for their children's college education. And quite frankly, we're seeing these a lot more often. OGE has reduced the reporting requirements for this type of holding, And if you're dealing with 529 plans with your filers, OGE has a specific advisory on this issue. And I really recommend that you go to OGE's website and track that down. Item 5, Axtron ADR. Apparently it's not an EIF. We have a value, we have an income type, and an income amount. Okay, the reason I put that in there is that an ADR is an American depository receipt. It is a more complex financial holding. It's beyond stocks, bonds, and mutual funds and cash accounts. If you are not familiar with an asset that the filer is reporting, then you will need to track it down to find out what it is. And trust me, I am not a financial expert. But the good news is that OGE has a lot of information on more complex financial holdings. And just so you know, an American depository receipt is a means in which an American investor can invest in foreign entities without essentially shipping money overseas. Those are reflected here in America's stock exchanges, and that's fine. I have to tell you, it's way over my head. I never knew what an ADR was. I was barely competent in checking and savings accounts. So bottom line is, if you don't know what it is, you need to track it down. Okay, item 6 is a savings account. Obviously, it would not be an IEF. I'm assuming it's a cash account. It has a value. It does not have an income type, but we would assume that the income would be interest. We would check that with the filer, and we do have an income amount. The takeaway from this one is that OGE's recent guidance states that filers no longer have to report the name of a bank or other financial institution where the filer only has a cash account. My understanding is that the reason for this is, once again, these are publicly releasable, and if the filer had to report the institution name, it might make it easier for the filer to get hacked. Okay, let's take a look at, is that 7? Okay, we should be at part 7 now. I think I went too fast. Thank you, Patrick.
Sorry, Mark.
Appreciate that.
I got a little ahead of you.
Okay, part 7 is where the filer reports transactions. A transaction is basically just a purchase or sale of a security or real property held for the investment value or production of income. Our filer has reported transactions. The first thing I want to emphasize is that you should already be familiar with the extra reporting requirements of the Stock Act. That dates back to 2012. We've been dealing with it since then, so hopefully your agency is already familiar with it. If not, if you're new or newer, there is a lot of guidance on OGE's website. Entry 1 is IBM, which I presume is a security. It's a sale. The date is supposed to be during the reporting period, hence the 2 X's of a reportable amount. Entry number 2 is GE, which once again, I presume is General Electric stock. It's a purchase, once again, during the reportable period of a reportable amount. These entries should have corresponding 278T or transaction reports with the agency. In addition, if your filer is a PAS type, which is a presidentially appointed and who requires the advice and consent of the Senate or your DAO, those 278Ts should also be filed with OGE. So bottom line is, hopefully your file at your office has those 278Ts. I have to admit, a couple of my agencies have broken my heart recently because I had to go back to them because they sort of dropped off on forwarding them to OGE. Just please remember that as a takeaway from this entry. In addition, the purchase of GE should probably have been reported on Part 6. So if our filer didn't do that, we can go back and get that reflected. The big takeaway from this is the whole concept of the 278T. If your agency isn't doing that, trust me, OGE will ask about it when they do the review. So you may want to double check that when you get back.
Yeah, I also like the 278T because it allows us to give contemporaneous or more contemporaneous advice to employees. So I remember in the old days before the 278T, sometimes you'd see a purchase that's problematic, but it was purchased 10 months ago. And 10 months is a lot of time for someone to run across a potential conflict of interest. So while the 278T feels like more work, it should, if it's functioning properly, allow us to provide better advice as well.
Well, it's definitely more work. And also, Patrick is totally correct. I mean, this process was set up back in 1978. An annual report covers the prior calendar year, but the report itself is not due until May 15th, which is...
It's a long time.
It's a long time. So if we're just discovering that now, wow, it's probably too late. I guess one of the things we like to emphasize is that for the agency ethics official, we'd like you to be proactive with your filers. And in fact, if your filer was contemplating purchasing General Electric advice, or for example, inherited General Electric advice stock, what we would want you to do, what we would want the filer to do is contact you first or contact you the next business day. So hopefully you have a really good back and forth with your employees, especially your senior employees who have a much higher potential for a conflict of interest. Okay, let's move on to entry number 3. Vanguard Standard & Poor 500 Index Fund. It's a purchase during the reporting period of a reportable amount. Since that entry appears to be a mutual fund, it would qualify as a it would qualify as an EIF, which would not be required to be reported on a 278T. OGE has left it up to the agencies as to how they want to handle this reporting requirement. Under the statute, the filer is not required to report this during the year. But you know what? It may be easier if the filer does just continual 278Ts, and that way the filer doesn't have to go back in time when the annual report is due and come back with all that information. And also potentially, if it's a sector mutual fund that did turn out to be a potential conflict of interest, once again, as Patrick indicated, we'd like to find that out as soon as possible. Also, since that was a purchase, that should probably also be reported on Part 6. I keep wanting to say, are there any questions? But since we can't do that. Okay, let's take a look at Part 8. This is where the filer reports liabilities or debts. Item 1, the filer reports what appears to be a mortgage on a personal residence. And once again, I'm going to refer you back to the Stock Act. Filers who are PAS types presidentially appointed with the advice and consent of the Senate have to report personal mortgages. Other 278 filers do not. So if you have a PAS filer, Yeah, presumably since 2012, that filer has been reporting personal mortgages. If this just popped up, maybe it was a recent purchase. We don't know, but you probably want to track that down. Item 2, Bank of Scotia, mortgage on rental condo, the amount, the year, the rate, the term, that appears to be technically correct. However, if it's a rental condo, we would presume that any income would have been reported on Part 6. As a reminder, for our training purposes, we are going through this report one part at a time. However, certain entries would be reflected in other parts of the report. And when you're at the agency doing the review, you're probably flipping back and forth just to make sure we're consistent with that. Okay, let's take a look at Part 9. This is where the filer reports gifts and travel reimbursements. Once again, just as a reminder, reportable gifts are a separate issue from standard of conduct gifts at 5 CFR Part 2635. The filer may have to report more gifts whether or not they are a potential standard of conduct issue. Let's take a look at entry number 1. We have a name, Bob Jones. Bob Jones apparently lives in Scotia, and yeah, I use Scotia a lot. The brief description is a bar mitzvah, and we have a value which is over the reportable range. Item 1 appears to be a gift to a dependent child that was given totally independent of a relationship to the filer. This appears to be over-reporting, and we may want to talk to our filer to see if this entry could be removed. The reason I use this as an example is because I recently saw it on an entry on a report. And once again, the reports that come to OGE are from the very senior PAS types, which have already been vetted by the agency and then come to us. I was a little bit surprised because conceivably, the only way this would be reportable would be if the donor was attempting to bribe or otherwise sway the filer. And I got to tell you, nobody reports bribes. The other concept is that the filer says, I want to over-report because I have nothing to hide and my child got an expensive gift. Bottom line is, I really think that should have been handled at the agency level, and I was a little surprised that it was not. Okay, let's take a look at entry number 2. It appears to relate to travel. Now, once again, I'm presuming you're familiar with the concept of 1353 travel, which is where the federal government agencies can accept a gift of costs and travel reimbursements for their federal government employees to go to functions that are related to their mission, typically conferences and things like that. If that was the situation, then it would be a gift to the agency, not the filer, and so would not be reportable. In addition, we presume that the agency would have approved this travel in advance. However, if it actually was a gift to the filer, then the entry is not technically sufficient. We would need a travel itinerary, including the date of travel and the nature of the expenses. Presumably, the ethics official would do a conflict of interest analysis on the data then. And if our agency ethics official was stunned by this, then maybe we need to do some more talking with our filer.
No, I always found when I was reviewing these reports in an agency that the most useful thing to be able to do would be to cross-reference the employee's advice file when you're looking at these gifts to see if you've seen them before, because very often you have a question about whether it's to the filer, whether it's over-reported, whether you've seen it before, and you look in that file and say, oh, we did a 1353 authorization for that, so we can remove that from the report. Or we looked at it and determined it was a gift to the employee, and we've given the advice, and it was appropriate for them to accept that. So, sometimes when you see these, some of the outside activities, it's really good to dig into the advice file.
Absolutely. And along those lines, if you have a situation like that and you think it might be helpful to give a little bit of background information in your notes or comments, by all means, feel free to do that too. But definitely keep your notes and comments in your agency files as well. Okay, that's all I have. I hope this was of some value as just a refresher lecture, but definitely, please, the one thing you take away from this is to remember that there's a lot of information and guidance on the OGE website. I used it a lot back when I was in my agency, and also if you have access to your OGE desk officer for your agency, that's also a great resource. They won't tell you what to do, but a lot of times they can tell you where to look and where to find guidance.
Excellent. Well, thank you very much, Mark, for walking us through this exercise and reacclimating us to some of the issues that we're likely to see during the annual filing season. I'd like to also just remind everyone briefly that we do have on the YouTube channel, youtube.com/OGE Institute, a playlist that's dedicated solely to financial disclosure issues. So if you'd like some more about less common financial instruments, we have a number of presentations about those, as well as some of the more sort of esoteric issues that come up only periodically on the public financial disclosure reports. So thank you all for joining us. We hope you found this to be helpful, and we look forward to joining you for future broadcasts. And as always, if there are topics where you feel like you would like training, there's something that OGE could be doing better, please let us know, because we do try and be as responsive as possible to your training needs, of course, resources allowing. So until next time, I'm Patrick Shepard.